sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in jail.
All right, folks. Today we've got one of the most outrageous sovereign citizens to ever appear on this channel. This guy's ego is off the charts. He flat out refuses to answer any questions and tries to outtalk the law itself. But luckily, he's up against the best in the game, Judge Oakley. This isn't just any courtroom moment. It's a masterclass in judicial patience and authority. Judge Oakley stays cool under pressure and shuts down the nonsense like a pro. It's honestly wild how far this guy tries to push it, but the judge never lets him take control. Watch closely and let us know in the comments. How do you rate Judge Oakley's handling of this situation? Did he nail it, or should he have come down even harder? Drop a rating from 1 to 10, and let's dive into one of the most intense courtroom showdowns we've seen yet.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the Constitution.
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
so today,
You have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes
multiple
or
arguments.
no?
You know, this right here is the biggest issue with sovereign citizens. They constantly twist courtroom rules like they're starring in some low-budget legal drama. It's fake, it's shady, and honestly, it's why so many people, myself included, can't stand them. Let me be clear, I'm not a sovereign citizen, but if I were, I'd at least have the sense to be respectful. Why risk a contempt charge just to play games in front of a judge? I'm not saying they're the absolute worst people on the planet, but seriously, if they could just chill out and show a little respect in court, maybe, just maybe, we'd toss them a crumb of dignity. But no. Half of them refuse to answer even the simplest questions. It's like they have some ego-driven allergy to basic communication. I get that they think they're above it all, but come on. This stuff doesn't help their case at all. Just answer the question. It's really not that deep.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
and
it?
it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party.
All right, so this guy is actually out here claiming there has to be an injured party for his criminal case to be valid. Like, dude, is your brain on vacation? Let's break it down for Captain Clueless real quick. In the real world, an injured party doesn't have to be someone limping into court screaming, "He got me!" In criminal law, the state itself is the injured party. Why? Because breaking the law affects everyone. That's why the judge hit him with the reality check. The injured party is the people of Michigan. You don't get to break laws and then act like it doesn't count just because no one's physically bleeding. That logic is like robbing a bank and saying, well, unless the vault files a complaint, I'm innocent. Like what?
Who have I injured for the record?
The state of Michigan.
How can I
are bringing the charges?
How can I injure the
state?
Sir,
sit down. Sit down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still out.
That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
It says it's
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
This right here is exactly why I love this judge so much. The way he handles these sovereign citizens, chef's kiss, absolute perfection. He doesn't let these clowns run the courtroom with their nonsense, and he's never afraid to call them out when they try to twist the law to fit their delusional beliefs. Now, I saw some of the comments on my last video yesterday. Some of you said the judge was too offensive. Respectfully, I think you've got it wrong. We need that kind of firm attitude. These sovereign citizens act like laws don't apply to them, and sometimes a bit of sarcasm or sternness is exactly what it takes to shut them down. Let me know in the comments. Do you think the judge is too harsh? And if so, explain why. Because, honestly, there's no good reason to think that. This guy is wasting taxpayer dollars, stalling court proceedings, and making a total mockery of the system. The judge fining him or raising his voice. Totally justified in my book. What's the alternative? Just let them keep turning the courtroom into a circus. Yeah, no thanks. All right, let's get back to it. Something tells me this sovereign citizen is about to rack up another fine, or maybe even something worse.
What grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If it's a hearing, or
you didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
Man, I really wish we could see this guy's face right now. The amount of time being wasted just trying to get him to understand the absolute basics, like what a probable cause conference is beyond irritating. It's not rocket science. It's literally just a meeting to determine if there's enough evidence to move the case forward. That's it. But this dude is out here acting like he's studying for the bar exam, and don't even get me started on the grilled cheese moment. That had me giggling. The judge probably sat there thinking, how do I explain this to someone with an IQ of -12? And then just went with grilled cheese like, fine, maybe this will get through to him. What do you guys think? Is he genuinely clueless, or is he just playing dumb to try and weasel out of this? Personally, I think it's a bit of both. He thinks he's being clever, but in reality, he looks like the dumbest person on the planet right now. Let's dive back in because I've got a feeling things are about to get even more explosive.
Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay, listen. You can't tell me something and then just disagree with me and think it's, listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run.
This court hearing should have been wrapped up like 10 minutes ago, but nope, here we are, watching this sovereign citizen drag it out like it's his personal TED Talk. It's wild how these people come into court acting like the judge is their private legal assistant, demanding explanations for basic legal procedures they should already understand, or that their lawyer could have easily explained. At this point, I'm genuinely wondering, is this just stubbornness or something deeper? Because it's starting to feel like a full-blown disconnect from reality. Judge Oakley is doing everything he can to keep things on track, but if even he can't get these clowns to follow basic courtroom rules, what hope is there? Maybe more. Stern warnings could work, but honestly, if this guy interrupts one more time, a night in jail might be exactly the wake-up call he needs to sit down and rethink his entire circus act. What do you guys think? Has the time come for the judge to finally drop the hammer? Let's dive back in and see if this guy can finally shut up, or if he's about to earn himself a cold, hard night in a cell.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you.
Boom. Just like that. 30 days in jail. Honestly, if that isn't a wake-up call for every sovereign citizen out there, I don't know what is. If you're walking into Judge Oakley's courtroom, maybe, just maybe, take a second to rethink your life choices. Better yet, hire a lawyer. Any lawyer. They don't even have to be great, just someone who knows the basics and won't try to argue legal fantasy. This guy really came in thinking he was some kind of legal mastermind, demanding things during a probable cause conference like he was running the show. All he had to do was answer a few basic questions and he probably could have walked out the door. But no, his ego told him he could outsmart the entire legal system with word games and nonsense. Spoiler alert, it didn't work. My favorite part? When Judge Oakley broke it all the way down and proved the guy was, in fact, the person named in the case. The judge literally said, "You showed up to fight the case when I called your name." Like, how much clearer does it need to be? It's wild how this guy really thought he could talk in circles and come out on top. That ego trip landed him right in a jail cell, and honestly, I don't feel bad. The law isn't a suggestion, and judges like Oakley aren't here to play games. Maybe next time, these sovereign citizens will realize they're not smarter than centuries of legal precedent. Let me know what you thought of the case. Was Judge Oakley too harsh, like some people said in the comments on my last video, or was he spot on? Personally, I think he nailed it. Perfectly handled from start to finish. If you enjoyed this video and want more wild courtroom moments, don't forget to like and subscribe. It seriously helps the channel out, and I appreciate every single one of you for watching. Thanks so much. And take care, everybody.